Meet Jashandeep, an international student whose Canadian dream almost collapsed after an immigration officer mixed up dates and dismissed his medical history. He arrived in 2019, was hospitalized in 2022, and granted authorized leave, then developed a blood clot in early 2023 and paused studies. Even with a signed job contract and a valid LMIA, the officer doubted his credibility and refused his work permit, citing inconsistent timelines. The case went to federal court, where the judge found the refusal didn't add up. Key dates were misstated and important medical evidence was ignored. The court allowed a judicial review, quashed the refusal, and sent the file back for a fresh decision, showing that sometimes the problem is how your story was read, not the story itself.
Today's case shows why your words on paper can make or break your immigration future, and how the law actually expects officers to read, understand, and fairly assess your explanation. We are talking about Singh versus Canada 2025 FC 2019, a work permit refusal that was quashed because the officer misunderstood key facts and failed to engage with the applicant's evidence. Mr. Singh was a former international student who became seriously ill, missed school, and later tried to transition to a work permit. He submitted hospital records, prescriptions, and proof that his school had approved an authorized leave of absence. Despite this, the officer refused his work permit, saying the purpose of his stay was inconsistent with temporary residence and that he was not a genuine worker, partly by misreading the timeline of his LMIA and medical leave. The federal court found that the decision was unreasonable because it misstated the dates and ignored key evidence. Now, why does a well-crafted explanation letter matter so much in this context? Under the Immigration and Refugee Protection Act, temporary residents must satisfy an officer that they will leave Canada at the end of their authorized stay, and officers have broad discretion when assessing whether a person is a genuine student, worker, or visitor. The regulations build on this by setting out conditions for study and work, including continuous study, authorized leaves, and the need to comply with the terms of your permit. What Singh shows is that when your life does not follow a straight line, illness, gaps in studies, returns to your home country, it becomes essential to connect those facts to the legal tests the officer is applying. A strong written explanation does three things: tells a clear story, craft legal arguments, predict the concerns. When this is done properly, it not only helps the officer, it also creates a solid record if the case ever goes to judicial review. At Moving Life Immigration Solutions, this is exactly where the work begins. We do not simply upload documents, we craft them. We work very closely with each client to understand their medical history, their immigration timeline, and the precise legal relief they are seeking, whether that is a work permit, relief from a removal order, or success on an appeal. Singh versus Canada is a reminder that when the decision maker gets it wrong, the courts can step in. But it is your documentation and your explanations that make that possible.
If your situation is complicated, gaps in status, medical issues, prior refusals, or a removal order, do not leave your story half told. Reach out to us, reach out to Mirza at Moving Life Immigration Solutions, and let the experts help you put your facts and the law together in a way that truly reflects the relief you are seeking. Please subscribe to our channel and email us your questions. We are happy to help everyone. See you on another case. Goodbye.